Advocate, if you're able to hear me, evening, welcome to News at Prime. So we've been talking in the last 24 hours about the appeals by the former president, or at least the application for leave to appeal, and the Correctional Services Department indicating it intends to do the same. Apart from the fact that Jacob Zuma is a former head of state, how unique is this situation right now?
Okay, thank you. Good evening to you and the viewers as well, Nthambeleni. I think you can see that the news were not well received in reading what is actually happening on the ground. But I think what is important in South Africa is the respect of the rule of law and the orders that comes out from our courts. We have seen what happened in the recent past in relation to the unrest that happened in KZN, and also in some parts of Gauteng. So the judgment has been given by the court, which is a court of law, and then the judgment ought to be respected. And we have noted that there is a leave to appeal that has been filed by Jacob Zuma's legal representatives in relation to this matter. So obviously, when the leave to appeal has been filed, there are processes that have to be followed for the leave to appeal either to be granted or to be denied. And then that is based on the reasons that will be on the leave to appeal itself. So if that leave to appeal finds joy in the judge that has had the matter, then he's going to grant that maybe perhaps a different court may have a different look and a different feel on the very same matter based on the very same facts. And then if not, then you have to then petition to another court to actually listen to the very same matter. So legally speaking, this is where we are now.
And I'm wondering about the lengths to which both the Correctional Services Department and, in fact, the former president's legal team would have to go to prove that there's been a misunderstanding in law from the High Court, because Correctional Services, in its statement last night, said that it believes that the court, has erred in its interpretation of the relevant legislation. At the heart of this is that the former Commissioner, Arthur Fraser, went ahead and approved medical parole, even though the Medical Advisory Board had said that the former president, did not meet the standard.
Yes, precisely, Nthambeleni, you're correct, because here is about following the letter of the law. So if there is no following of the letter of law, we have the situation that we're currently facing, where you have a misinterpretation, where it comes from the commissioner in relation to the act itself, in relation to the release of the former president. And surely the law must be tried, and it must be seen to be tried. So if there's a law that applies differently to different people, then you have a situation of an animal farm. So the courts are trying to bring certainty to the law, and if you as the Correctional Services feel that it's an incorrect interpretation and the application of the law, then you are well within your rights to file a leave to appeal and ask for a different court to actually look into it. But the way things are, it seems that there was a correct misapplication and misinterpretation of the Correctional Services Act as well.
And at this stage, the next court would also have to revisit the issue, and I'm not sure to what extent, so this way you can guide us, the issue of procedure, which is in a Medical Parole Advisory Board saying no, inmate X does not meet the criteria for release, and the commissioner saying he's overruling that, or B, the actual substance of whether the president currently is too ill for incarceration. Which of the two is likely to be weighed highest?
Exactly. Look, what is important is the medical reports that have been submitted. But if it's a one-sided affair of medical reports that has been submitted by the former president, medical experts, without the benefit of him being assessed by the medical experts on behalf of the state, it becomes problematic. And you have to find the reasons in two different opinions of a medical report to actually make a proper recommendation. Because when the committee is sitting, it must form a quorum and the determination has been made. And now, as you have correctly stated out, Nthambeleni, that on the other side they're saying no, he doesn't qualify, and then the medical report completely says a different scenario, and it paints a different picture altogether. So when you have to look into those things and reconcile them, what should stand above all those things is the legal position of the law and also the interpretation of the Correctional Services Act, and it must be applied without fear, without favor, and without prejudice.
The High Court did say that the time spent on medical parole by the former president should not be factored into actually serving his sentence. So basically, all the days spent out will not come off the 15-month sentence. Now that we're looking at an appeals process, what does that mean for the clock on the sentence? Does it freeze?
Yeah, no, it doesn't change. It simply means that the day he walks out of the correctional services facility, up to today, those days will not be counted, because he is supposed to have been incarcerated by that, in that particular period of time. So, the day that he walked out of the facilities, the court ruled that that was unlawful, and unlawfulness means that the entire process must start from the scratch. So he must be recommitted, and then we start counting from the day that he has left, because even sitting out today, we will still follow on the very same days that we are speaking about. The only difference is that now, from today, we'll be counting from the leave to appeal, when the leave to appeal has been filed against the judgment, because that will actually buy a little bit of time in order to resolve these issues relating to reincarceration as well.
Advocate Romeo Nthambeleni, good to speak to you, sir. Thank you for your time.
Okay, thank you very much.